Rather than going quietly into that good night, the Biden administration has decided to spend its last days preserving sex change surgeries for kids. Now, the Supreme Court has spent the week presiding over the United States versus Scrimeti, which could possibly overturn Tennessee's ban on so-called gender-affirming care for minors. Joining me now to discuss is Matthew Peterson, editor-in-chief of Blaze News, and Josh Hammer. He's a senior editor-at-large for Newsweek and the host of The Josh Hammer Show. So, Josh, does the Biden administration actually have grounds right now to intervene in a state policy like this?
Great question. In fact, this is actually a question that I was discussing just the other day with multiple former U.S. Supreme Court clerks themselves. It's actually not entirely clear to me how the Department of Justice was actually able to file a writ for certiorari, in the first place here. That's the writ, obviously, that seeks the discretionary review of the United States Supreme Court. It's the so-called rule of four, where you need 4 of the 9 justices to agree to hear a case. I actually have no idea, Jill. I frankly don't understand myself why the United States was able to intervene in this particular case there. Now, it is worth noting that they did grant additional oral argument time, as I think the whole world saw, to the transgender attorney for the ACLU, Chase Strangio, if I'm pronouncing his/hers last name correctly there. But nonetheless, this case is styled U.S. versus Scrimeti, which means that the United States is the lead plaintiff here. And that actually has a very concrete, practical application when it comes to Donald Trump and J.D. Vance and Pam Bondi, assuming that she's going to be the AG pick come January 20th. Namely, they can move to withdraw this case. And specifically, they should make a motion to what is known in legalese to dig it, D-I-G, which means in SCOTUS nomenclature to dismiss it as improvidently granted. Now, it's actually an interesting question when you have a motion to dig a case after oral argument has already been granted. We've been here before. Sometimes they'll dismiss it. Sometimes they will not dismiss it. And the reason why they might not do so in this particular case is, again, because you had the ACLU attorney there who gave argument. It wasn't just the Solicitor General of the United States, Liz Prelogar, there. But it's a somewhat arcane procedural dispute that the justice will actually have to have. At a bare minimum, I think you probably should go ahead and make that filing, because there's no reason why the United States should be in the procedural posture of suing Tennessee for a commonsensical, civilizationally sound law, the likes of which we have here in place from the good people of the state of Tennessee. I guess the good news, Jill, is that either way, even if the Trump-Vance administration moves to so-called dig this case and that motion is denied, then we're likely still looking at a good outcome. I was pretty happy with the way this argument went. It could have gone a little better, but I was overall pretty happy with it. So I think we're looking at a good result here in all likelihood either way, I think.
Let me just step aside from the legal argument and just think about what they're saying in terms of the facts, because it really is astounding how these people, let's put it this way. It's astounding the discrepancy between the two sides. On the one side, you have someone saying, the ACLU lawyer, claiming that less than 1% of minors who undergo this surgery have regrets. And then you have Tennessee and the Attorney General saying, no, actually 85% desist from transition. Do you have any thoughts about that? It seems like you really do have two sides talking in completely different universes at this point.
Well, Matt, there's a reason for that. That's because what you saw at SCOTUS on Wednesday, I think, are 2 diametrically opposed conceptions of the human person. You saw 2 diametrically opposed conceptions of anthropology, of what it means to be human in the first place. On the one hand, you have the ACLU left-wing argument, which is that human life is basically a pick-your-own adventure where you flip through a different page to kind of choose your sex, and you can change your identity. You can grow some facial hair. Maybe you chop off your appendage down below, and then you can identify something else there. On the other hand, you have the old-fashioned view, the view of Genesis 1:27, male and female, God created them, which you don't even need the Bible. You could basically just need good old-fashioned common sense. That's the way it works. We literally have XX and we have XY chromosomal structure there. The point, though, Matt, and I think that you of all people will appreciate this, is that you have to choose. You have to come down on the side of one of these views of the human person. Neutrality here is just not an option. You cannot just toss it out and say it's up to every parent to decide, what view of the human person you want his or her child to be there, whether or not Sally can become Sam or vice versa there. No, you actually have to put a thumb on the scale from both a political perspective and indeed from a judicial and a jurisprudential perspective here. At some point, you actually have to say, that the moral heart of the issue in this particular case dictates that there is male and female, and that we are not going to arbitrarily concoct some sort of pseudo classification based on alleged quote unquote transgender status, the likes of which would get heightened scrutiny in this fabricated, manufactured tiers of scrutiny nonsense that leftist lawyers have created when it comes to 14th Amendment analysis there. But Matt, you have to choose, because as you and I both know, my friend, the only way out is through. And that is the task right now before these justices. Again, I'm optimistic that they will get it right. I am hopeful that in the majority opinion, or at least in one of the concurrences there, that we will get some morally forthright language, the likes of which I've just described.
Yeah, I couldn't agree more. I mean, this is a civilizational issue, and it's an issue that strikes at the heart of really whether you can be citizens with people who disagree about this. And I don't say that lightly. How you can be part of one political entity when you disagree on this is really, it can't happen. It won't last over time.
Yeah, and on that note, Ketanji Brown Jackson, a justice during the oral arguments yesterday, was actually trying to compare transgender surgeries to interracial marriages. Watch this.
The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Josh, I listen to that and I say, you know what, I'm going to need a legal brain to help out and try and to decipher what the argument that she's trying to make here.
Well, she's very clumsily, I think clumsily is actually a very charitable way of putting it. She's very clumsily trying to analogize Tennessee's prophylactic law protecting vulnerable youth from the predations of gender ideology to the old anti-miscegenation laws that pervaded and proliferated in the Jim Crow South prior to the Loving versus Virginia case of 1967, which dealt a final blow to these Jim Crow era bans on interracial marriage. I think a less charitable way of trying to analyze what Ketanji Brown Jackson has told us is that this is just rank sophistry. You know what this reminds me of, actually? This reminds me a lot of Sonia Sotomayor, a fellow dim-witted hack on the U.S. Supreme Court. It was during the oral argument in the Dobbs abortion case, the case that overturned Roe versus Wade. And Sotomayor is asking a question of Scott Stewart, who is the Solicitor General for Mississippi, who was ultimately the successful lawyer who overturned Roe versus Wade, God bless him. And Sotomayor literally asked a question that, you would be forgiven for thinking that like a drunk 18-year-old in his college freshman dorm would have asked, which is that she goes, counselor, but like, how can we actually know when human life begins? Oh yeah, because no one's really thought of that one before, right? That's literally what I thought of, Jill, when I saw this exchange with KBJ. And I guess, the bottom line conclusion that I have here is let's not forget how Ketanji Brown Jackson was picked for the court. She was picked when Joe Biden explicitly said, upon Stephen Breyer announcing his retirement, he explicitly said, I am going to choose a black woman. Well, guess what percentage of the national lawyer pool are actually black women? 2%. So when you announce from the get-go that you are excluding 98% of the possible lawyers for one of the 9 most important lawyer jobs in the country, apparently this is what you get.
Well, the good news is now with the Trump administration coming back, DEI will be a thing of the past, it looks like. Josh, thanks so much for joining us.
Pleasure, guys. Thank you.
MP, I saw your smile when he was talking about dim-witted injustices in the same sentence there.
You have to. Josh is right, and the thing is, people just need to say this out loud. People should be embarrassed. We need to embarrass more people in this country. Anyone who considers themselves a member of elite society who is okay with putting these people on the court and who's okay with this kind of idiocy, just out in public, they should be embarrassed of themselves. We need to shame people more because it's outrageous. It's dumb, but it's not something that's ultimately laughable. I was laughing a minute ago at some of Josh's choice words, but it's not ultimately laughable. It's ultimately shameful and reflects on this country in a terrible way. And anyone responsible for it needs to be embarrassed, and we need to call them out on it.